And furthermore, Your Worship, the state applies that count 8, possession of firearm be withdrawn.
So which means now the accused will be facing 21 counts.
That's correct.
Please stand up, Mr. Chauke, before anything, so that we can deal with this count that is withdrawn. Mr. Chauke, the state indicates that they have added 2 more counts, which is culpable homicide with the alternatives as count number 21. And the other count is reckless driving, which is count number 22. However, the state withdraws the charge of possession of firearm against you, which is in count 8. That means now you will be facing 21 counts instead of 22 counts. Thank you, Senator. Advocate Maburna.
Thank you, Your Worship. I guess my learned colleague still wants to address the court.
Oh, okay.
So we have brought an application for substitution of the charge sheet.
So you haven't?
We apply for the substitution.
Substitution of the charge sheet?
Correct.
And by doing what? Substitute what to what?
With the updated one.
So have you combined all the
That's correct.
counts in that new charge sheet? You have drafted the new charge sheet, in other words?
That's correct.
No annexion.
That's correct.
Thank you. Advocate Maburna, there's an application for the substitution of the charge sheet, meaning that now the old charge sheet is going to be replaced by this new charge sheet, which contained the additional charge. I would say additional charge because the other charge is withdrawn.
As the court precedes, we cannot stop the state from bringing more charges and similarly from bringing new documents to the court because Section 81 of the Criminal Procedure Act appears to allow them to do so.
Thank you, Advocate Maburna.
As the court precedes.
Advocate Matabata, they are fetula our Yalakamala, Arana Matao, Kabakaneta, Banyaka, o gala melato e mengwe merao ba o phumole mengwe ba o ketša e mengwe ke maatla a ba bennago bjale ka ba lefapha la botšhotšhisi.
Now, what is clear is that the state was not ready to deal with the pre-trial today because the court will be aware that the state has decided today to add additional charges. The defense needs to be afforded the opportunity to consult with the accused to obtain instructions in relation to those additional charges.
Se se be molaleng ke sa gore ba lefapha la botšhotšhisi le kgomo lebe ba sa lokela go ka swara kopano ela ya gore re tsebe gore a na ka moka diaperesiamo re ka kwanela letšatši la tsheko ka baka la gore ba kgethile le kgono go ka tsebiša kgoro gore ba oketša melato ka e mebedi ebile ba okela morago molato o motee se se ra gore molatofatšwa o na le tokelo ya gore bjale a tlile sebaka le boramolao ba gate gore ba dule fase ba ithere ba boledišane ka melato ye mebedi ba reng ya tlaleletšwa gore ba kgone go hwetša ditaelo tša go kwagala go tšwa go yena molatofatšwa gore ge ba tlo botša kgoro seemo sa bona e bane gore ba kgonne go ka bolela le molatofatšwa pele.
Your Worship, we were finished with the particulars of these cases. I don't want to say last night, but it was yesterday, just around 5, when they were delivered to council's chambers.
Kgatišo ya dokete tša o tlaleletša melato le ditatofatšo tše e leng gore di a tlaleletšwa di amogetše maabane a ke nyake gore ke re maabane bošego ba lata e fela di amogetšwe ka 5 ya thapama ge di tlišwa kwa diofising ba dikantorong tša ramolao khumana.
Right. Now, that is the first glitch which would impact on the proceedings today.
Ke ntho ya mathomo e leng gore ke tlo šitiša gore re tšwele pele ka tshepišo ya lekgolo.
Now, the second glitch, which is the major one, relates to the decision of the Director of Public Prosecutions to consolidate or to join the charges which compound to now 21, as we have just been informed.
Ntho ya bobedi e leng gore e šitiša tshepišo ya lekgolo ke sephetho sena se tšerwe ke molaodimogolo wa batšhotšhisi gore ba tlhakanye melato e ka moka e sekwe kgorong ye tee e le ye 21.
The Director of Public Prosecutions would have had, maybe they would have thought they have unfettered powers of doing as they please in their decision to compound these charges.
Molaodimogolo wa batšhotšhisi a ka no ba ile a nagana gore o na le maatla a go se fele mohlomongwe a e leng gore a mo dumelela gore a tšee melato o tšwa mahlakoreng a go fapana a kopanye gore a be lefelong le tee.
Now, in that process of centralizing the charges, certain procedural rights of the accused were trampled upon.
Bjale ge ba tšea sephetho se bue sa gore ba kopanya melato e gore e be lefelong le tee go na le ditokelo tše ba leago tša molatofatšwa tše e leng gore ba ile ba di gataka.
Whose phone is that? Oh. No, it's fine. If you're but members of the public, please switch off your phones. I don't even want you to place them on silent. It's only the media houses allowed to have their phones open because they are using them for the proceedings, which they were allowed to use previously upon their application. Thank you.
Lena maluka setšhaba ba letlileng go tshireletsa ka mogoro a la dumelelwa go laeta difounu go di bea silent no ba o di tima ba dumeletswe ka kgotla difounu ba di bula ke ba go phatlalatsa ditaba ka gore gore ba file tumelelo ya go dira bjalo re nyake difounu di lela ka mo go o ditseng lena maluka setšhaba.
Yes, Advocate, proceed.
As the court pleases. I was on a point where I was saying, in their quest to compound the accused's legal problems, those that are vested with state power, they decided to reawaken cases which were finalized either by alternative dispute resolutions, either were withdrawn because the complainants had decided to withdraw them, and decided to add them to the last case which was opened against the accused, which comprises in the counts, which is your count 1 to count, I think, 3 or count 4 in these proceedings. And those are the counts which arose on the 19th of October, 2025.
Ben, mona tfajwana le ditokelo go ya le ka molaotheo wa naga ba filo matla go ya le ka maemo a bona ka mo go lefapha la mmuso goba la botšhotšhisi ba kgethile go tsoša melato e leng gore e be e fedile ye mengwe e be e fedile ka baka la gore o ile ga ba le ditherišano magareng a letlhakore la molatofatšwa le la molle ba fitlhelela kwana gore melato e se sa tšwetšwa pele kgorong ya tsheko ye mengwe ya melato e ba e tsošitšego ke melato e leng gore e be e gogetšwe morago ka kgopelo go tšwa go balle wa beng ba melato eo ba kgetha gore melato eo ba e tsoše ba e kopanye le melato ya go tšwa tiralong ya di-19 tsa October ngwaga 2025 e leng melato ya mafelelo e leng gore molatofatšwa o swanetše yona ye bue ke melato go ya ka palo e le molato wa mathomo ke nana go ya wa boraro ba wa bone.
Now, in relations to those, we regard them as proper counts for which the accused has to account in this court. In relation to those counts, we are ready to proceed with the pre-trial.
Then, ditatofatso tše even tša mathomo wa fela o tša boraro ba tša bone ke tšona tše e leng gore re bona e le tšona ditatofatso tša maleba tše e leng gore molatofatšwa o swantše a ka lebane le tšona pele ga kgoro ye ebile ke tšona tše e leng gore rena re loketše go ka tšwela pele go ya tshekong mabapi le tšona.
Now, in relation to count 5 until count 21, which are a product of the illegal centralization, those decisions, all of them, we intend to subject them to a proper review before the High Court.
Then, we go ditatofatso ya ka molato wa botlhano wa go fitlhela wa bo 21 ke melato ba ditatofatso tše e leng gore rena re ikemišeditše go ya go ilwantšha kwa kgorongkgolo ka go dira kgopelo ya gore baahlodi kwa kgorongkgolo ba lebelele sephetho se se tšerego ke molaodimogolo wa batšhotši se go ya ka rena re bona se se molaong sa gore a kopanye goba a tšee melato ela a e kopanye le tiragalo ya mafelelo ya di-19 tsa October 2025.
Our main ground for review is going to be that there was an abuse of power and that a legal process was directed for ulterior objectives.
Mabaka kulu arena au ishafupelo ye u balaudi ba tudi ba hulu kwa high court ki sama tromo gore ubideli ushumishwa bushahidi amata ki ba lefapha la botšhotšhisi ebile ba ile ba shumisha tshepedišo ya semolao go phethagatša maano a bona a mane.
And obviously it is not this honorable court which will be expected to make a decision on that aspect of review. So we are going to ask this honorable court to grant us the opportunity to prepare a substantive application for review, and then we'll have to ask this court to also postpone the pre-trial, because the state is just not ready, and we are just not ready now to begin with the pre-trial.
Koroi asiona ilongore ikota I just petma bilo kupelo ye renyaka ngoi tisha ya ka mokoro tlhalositse biale kupelo ya rena I tloba ya gore koro I re fesebaka sa hore re kgone o ka gatisha kupelo ya rena ya go tsenelela gore re kgone o isha go batho di bagolo re bushe re kupele gore kgoro e šutišetše pele temana ya gore re kgone go fahlela pele ga yona gore ana ka moka di ka ba di apere tshiamo gore re ka thoma tsheko ya molato.
Maybe just so that the court is able to follow where we are going and where we are coming. Your Worship, the initial step will be to write representations to the DPP to implore them to reconsider their decision to reconsider their decision to centralize the cases.
Then, gore kgoro e kgone go kwešiša gore a botse re tswa kae re lebile kae bjale ka letlhakore la molatofatšo. Ntho ya mathomo e re tlo e dirago go ngwalela molaodimogolo wa batšhotšhisi wa province ya Limpopo gore a lebelele ka boswa sephetho sela a se tšereo sa gore a tšee melato ka moka e leng gore molatofatšwa ka yona o ba latofatšwa ka yona a e kopanye gore e be lefelo le tee.
That exercise is going to take more than 2 months, the way we anticipate.
Bjale rena o ya le ka tebelelo ya rena kgato e uwe e ka tšea tekano ye e ka fitlhago le kgwedi tse pedi.
Because among others, we must find out from the DPP as to who requested this centralization.
Ka gore o tšee dingwe tša dilo tše e leng gore re tshwanetse o di kwa go tšwa go molaodimogolo wa batšhotšhisi ke gore ke mang wa kgopetše gore melato e ka moka e kopane e sekwe lefelo le tee.
We must also understand what were the reasons advanced as grounds for requesting the centralization.
Re tshwanetse re tle re kwešiše gape le gore mabaka a ileng a tšweletšwa bjale ka mabaka a tlišitšwego gore go feletswe go tla kgopelo ya gore melato ye e tlhakanywe e be filo mo teng.
Now, we will also seek to hear from the Director of Public Prosecutions in relation to the counts. There's a count that comes from Mankweng, there's a count that comes from Seshego, and I think there's one at Lehlohonolo. Those counts were withdrawn. We will want to understand the circumstances under which those withdrawn cases had to be reinstated, and we want to understand who requested that those cases must be reinstated and what were the reasons for those cases to be reinstated.
Bien, re tlo nyaka gape le go kwa le go kwešiša mabaka ao go tšwa go yena molaodimogolo wa batšhotšhisi gore melato ye ya go tšwelela mankweng sešebo le leboakgomo ye e leng gore go ya ka tsebo ya rena bjale ka letlhakore la molatofatšwa re tseba e fedile goba e gogetšwe morago ke mabaka a mafe a e leng gore a ile a tšweletšwa gore melato ewe e tsošološwe le gona ke mang a kgopetše gore melato e tsošološwe.
In addition, the director will have to answer the following question. When the accused was again recharged of these offenses, was he served with a J175? Is it a summons? Whether any J175s were served on the accused to have the matters reinstated, or how were these matters brought to court?
Now, ye nngwe ya dipotšišo ye e leng gore molaodimogolo wa batšhotšhisi o tlo tshwanela gore a e arabe go tšwa go rena ke ya gore mašala a molatofatšwa a pharwa gape ka ditatofatšo tše tša melato ye e leng gore be e fedile ka mokgwa o ela morago goba ka kwano magareng a molatofatšwa le mollo. A na molatofatšwa o ile a tsebišwa semmušo na ka go fiwa ditokomane tša go mo tsebiša gore bona ba na le goba ba tsošološa melato ela ka go mo fa tokomane ye e leng gore re tseba ka J175 e le ya go tsebiša motho gore melato ya tsošološwa le gona yo tsena neng kgorong ya tsheko ke ntho e tshwanetse re e tsebe gore na e tlišitšwe bjang gape pele a kgoro melato e.
And I think lastly, in relation to the charge, which is an aspect of the last counts which are going to be added, we understand the accused is going to be charged with reckless and negligent driving and maybe culpable homicide, where he lost his daughter in a tragic case. We want to understand in relation to that charge as to whether the prosecution's policy was properly applied there.
In respect of which charge?
The count where the state today, we are to come again. Count number 21, Yoshi. We want to understand if public prosecution policy was properly applied in
that
relation
one of reckless or negligent driving.
No. The culpable homicide. Yes, the culpable homicide count. We want to check if the person who decided on that count, whether he properly applied the prosecution policy directives of the NPA. And I can state it for a record here that it is not often where a parent who loses their child in an accident where they are also injured.
Okay, can I just stop you there?
Yes.
Because now you seem to be getting to the facts of the case. I don't want to hear that. If you are saying that in respect of count 21,
yes,
which is culpable homicide, whatever issue that you're going to raise with the DPP
will be dealt.
It will be dealt with,
correct,
not
Yoshi,
with me, because
as
I'm seized with the matter and I cannot hear the facts of the case when I'm still going to hear it procedurally and in the near future. Okay. Just mention culpable homicide, that's it.
Oh, it's fine.
Yes.
Unfortunately, you are sitting in this court.
Yes.
As the court where the matter is heard for the first time. That count is joined before this court for the first time.
Yes, but now what I'm saying is you seem to be getting into the facts. If you are going to tell me as to what happened, I don't need to know what happened now.
Yes.
Here, we postponed this matter to today for the purpose of pre-trial conference.
Yes.
And you are raising some issues which I need to hear you and listen and
It's Your Worship, it's fine.
Yes.
You can record it as follows. We are going to question whether the decision to prosecute the accused for count 21 was taken with a proper conscience of a prosecutor.
Well, ore ye nngwe e leng gore ba tlo nyaka go ikwa go tswa go molaodimogolo wa batšhotšhisi wa mo Limpopo ke ya gore Mashalang o tšewa sephetho sa gore molatofatšwa a latofatšwe ka molato wa go tlhola letlho la motho e se ka maikemišetšo e ka ba ka lebaka la bošaedi a na motho wa tšere sephetho sewe a ka ba ile a latela melao ya ka kwa lefapheng la botšhotšhisi Mashalang a tšea sephetho sewe le gona a ka ba dirile sewe ka letswalo la moya o e leng gore ko mo.
Now, maybe so that the court understands that we are not putting the so-called, we're not doing a Stalingrad on this case. If the state is intending to prosecute the accused for the case of Ladana, which is count 1 to count 3, we are ready to proceed from count 1 to count 4. We are ready to proceed with the pre-trial, and we are possibly ready to proceed with the trial in that matter.
Now, o bontšha gore gore a re leke o ka ditela tsebo ya molato kgatlhanong le molato gape re rata go tsebiša kgoro ye gore e tsebe gore ge e le gore ba lefapha la botšhotšhisi ba re ba nyaka go sekiša molatofatšwa ka molato wa mathomo ba go fitlhela ka molato wa bone e beng wa mabapi le tiralo e diragetseng kwa Ladana gona ge rena ka se sebaka se re loketse o ka tšwela pele o ka botša kgoro gore ka moka di apere tshiamo le o itlamela tungengwe ye mene re ka kwanela tšatši la tsheko ebile ra thoma le tsheko.
And we are also ready to do a pre-trial in relation to the attempted murder charge which allegedly happened in the workroom. Let's just find the date so that the court knows which ones we're talking about. Those we regard as proper cases.
Ebile re loketse le o ka thoma tsheko ya molato wa go leka go bolaya ola wa lewa kgomo ke sa no nyaka gore ramolao ba nthuše mo gore o ya le ka ditatofatso ba re ke molato o diragetse mme le ona o re bona bjale ka molato e leng gore o ya le ka molao molatofatšwa ba lefapha la botšhotšhisi ba loketse o ka mo sekiša ka ona.
Now, the rest of the counts.
You mean count 5 perhaps?
Let me just find.
Let me just see an attempted murder, which is alleged to have occurred in Libuakomo, Zone 8. Zone 8.
Does that involve someone being stabbed with a knife?
Yes.
Of Mutukishi Josebo River.
Yes.
Yeah, and charges connected to that one if there are any. We are ready on that one also to do a pre-trial and also to proceed with the trial.
Le ka molato nowe ba loketse o ka botša kgoro ye gore o tswa letlhakoreng la bona ba loketse o ka kwanela letšatši la tsheko le go thoma tsheko ya molato.
Now, if the court wants to understand where we come from all the withdrawn charges which were harvested from the storerooms to compound the accused legal problems, those ones we want all of them reviewed.
You want them to do what?
We are taking them on. Firstly, we are going to ask the director to.
So you are saying all the charges that were withdrawn?
Yes.
Those are the charges that you intend taking them on review?
Correct.
Pilaba tudi kwa koronkolo kuriba TSP yona uri kika bakala ini itusijwe lorwana babona usituka uri itush.
Now, to conclude, we are therefore asking the court to grant us a period of 60 days. We will use the first month to ask the director to reconsider his stance in relation to those counts that we've isolated, so that we should avoid further delays in this matter. If we find each other with the director, we will obviously come back and say we are ready to proceed with the pre-trial, and there will be no need for a review. But if the director insists with the consolidation and proceeding with those counts, then by all means we will be approaching the High Court.
Ya ufela itushushu kimuka elori ujwa upledisha notare nale mulaudi ogulwa bachuchi sirifika kwano rukubu ya mora kucha korora awa bele rulukiti ukatwela pili ka seku ya milatu.
Your Worship, the 60 days is not picked from the sky or from the air. It is with the understanding that correspondence in the DPP's office normally requires that the docket will be received by the, I think it's called the data center, where it will be received, and they will read it preliminarily, allocate it to an advocate who must then go and peruse. They might have to call for further information, and their turnaround is normally 30 days.
Bien. Majajia masitari ya kupelao arinoa jiamu lefafaunga moyeni. Ki majajia inumori ya kupela riela kao sipilisho ye numori ganchi ya la telwa ki mlauri mulu wawa kutisire ashijia mogeti dingwalwa cha urerishana liena ka malatu. Reaziva ori leas no pita ser narta ver mumareti sona uto kupela ori ba mutisije di doge ga muka jamalatu hadibale kimuka akano kupela ori balfa bala mchuchisi ba polisa ba mufe yengwetsi di mushu ya ka banga inyaka ora kono ku jiasiphethu bele ganchi se wesi jiatikano ya khwei.
Now we will need days for counsel to prepare the representations.
Because of Galamati, our Renaveleka or Amula Mulatfadra, Latishe, the Malajarena, the Toishaway and Amula Murava Chuchis.
Which then, if we are moving with the agency that we normally work with, we will need a minimum of 2 weeks from our side to do that. It is on that score that I proposed a period of 8 weeks, which is 2 months, to allow for, if there are slacks in the system, either from the DPP side or from our side. That will also afford us the chance now to speak to the accused in relation to the last counts which were added today. Worship, I have traversed all I needed to place before this court. Yes, yeah. Maybe if the court could allow us to hear from the accused if there's anything that we're leaving out.
Yes.
That's the court. Your Worship, we will also, as well, he instructs us now, he says we must inform this court that among the other things that we will require from the DPP, among other things that we'll ask for answers from the DPP as we do the representation, is that they must update the accused as to how far are they with the arrests of the corrupt prosecutors, corrupt policemen, and corrupt magistrates who participated in the withdrawal of those counts. The accused says
not supposed to go to Madanga Commission.
No.
Is it relevant to this court?
No, we're not there. But the accused says I must communicate that. It's important.
But I cannot entertain that. Really, I can't. I can't entertain that. The corrupt prosecution, the corrupt magistrate, whoever. No, that is not within my power.
I hear that, Yoshi, but...
Yes, I think you have to take it separately with the relevant forums to that, not with
It's okay, Yoshi. All that I wanted to say was...
I cannot really entertain.
Is the court saying it cannot place it on record?
I think we've got the commission, which deals with corrupt everybody. Not that this court can entertain that. I'm very sorry.
It's all right, Yoshi.
Yes. And I was not even a part to those proceedings. I don't know what happened. So it is a little bit unfair that such be brought to my attention. I cannot entertain that. If you want to entertain it with the DPP, you can do that aside, but it is not an issue that should be brought before this court. This court is seized with the trial of this matter as to what happened, where and how.
Yeah, well, I'm not sure, Yoshi, but it's okay.
No, but as a legal representative, you have to advise your client that, okay, certain issues cannot be brought to this court. I am seized with the application that you are making.
Yes.
And I need to make a ruling in relation to that application.
Yes.
As to other issues which are ancillary to this case, and where I was not a party, I don't know what happened in those cases. So I'm very sorry I cannot entertain.
I hear what the court is saying, but can the court allow me to address it, and then you can make a ruling?
On other issues, but not on the one that you want. The accused says you must inform me that you will also ask the DPP as to what happened to the corrupt prosecutors and the corrupt magistrate and whoever was involved in those cases. Please, I cannot entertain that. If you are addressing me on the issues that you are addressing me in relation to the consolidation of the charges, in relation to the addition of the charges, in relation to you making representations to the DPP as per the instruction of the accused, that one I have to listen and make a ruling after having given the state an opportunity to respond to your concerns.
Yes, Your Worship. May I then be allowed to place the accused case fully before the court in our application for a postponement to allow us to approach the DPP to reconsider the decision to consolidate?
I don't have a problem with that.
Yes.
The problem that
So
I had
this
was that one
submission-
of corruption of other members, like police prosecutors and all that.
It's
That
fine.
is where
Your-
I was saying that one I cannot entertain.
Your-
But with regard to the application
Yes.
to approach the DPP,
Yes.
I am fully aware that I must listen to that, and I have to make that limit.
That's correct, Your Worship.
Thank you.
It is on that. It is on that score that the accused says, in addition to the things that we are going to direct to the DPP to reconsider her position, you must not forget to inform the DPP that we have it on record that those counts were withdrawn because of corruption.
That is why I was saying that this is the issue which I reasonably believe it should have not been brought to me.
It's fine, Your Worship, but
Because you are going to make representation to the DPP.
That's
you
correct.
are allowed to put everything that the accused is instructing you to,
yes,
but not to raise it with this court. Although it will be part of the representation,
Yes.
and representations which I will not even have sight of,
Yes.
and representation which this court will not even be affected by it.
yes.
Okay, so that is why I'm saying that certain issues should not be brought to this court, because really, whatever happened in other courts, I don't know. I am only accountable for what is happening in this court, in Regional Court A, in relation to this case.
Yeah,
Okay?
those were my instructions,
Thank
Your
you.
Worship. And my instructions were as I couched them, Your Worship,
Thank you.
as the court pleases.
But just to make it clear before
Yes.
making any ruling, that issue of the last concern,
Yes.
the court will not consider. Thank you.
Well, that was not the point. We are not saying we're bringing it to you to consider.
No. But I'm saying that, remember, when you are addressing the court,
Yes.
these are the issues that you want the court to consider.
That's
because
correct.
Remember, it forms part of your application for the postponement of this matter
That's
in order
correct.
for you or the defense to approach the DPP.
That's correct.
Remember, this application is not going to affect the accused only. It affects the state, it affects the witnesses, it affects the court to deal with this matter within the prescribed time.
Correct, Your Worship.
That is why I'm saying that certain issues should not be raised by this court.
I hear
And
what
should not be raised to
I
this court.
understand. I
Thank you.
understand where the court comes from.
Thank you, Advocate. Thank
Although
you
the
for
court,
understanding.
although the court must appreciate that I'm not here to represent another person. I'm here to represent the accused.
That is why I'm saying that you are the representative as well as an advisor at the same time.
Yes, but
Yes.
if the accused says to me, inform the court that you are going to tell the DPP that certain things were said.
I don't know what you are going. I don't even need to know what will be contained in the representations. You have said enough.
Yes,
So this is the issue that I'm concerned about. That this issue,
yes,
which involves alleged corruption by whoever,
yes.
really, you did not speak it out. You should have advised your client that, okay, I will take this with the DPP.
No,
Okay.
but your Worship.
Thank you.
Well,
Let us not argue about that, Advocate, please.
I guess we agreed, Your Worship.
On what?
We agreed that I can only bring what the accused says. I must inform the court as best as I can.
But not
And that when
everything that this court is not supposed to hear.
No, Your Worship. And all I wanted to say was, when I do this, I don't have to worry about who feels how. I must only bring to the court what the accused says. I must tell the court, and whether the court does not like what the accused is saying, it's neither here nor there. The accused says to me, inform the court that among the issues we are going to raise with the DPP are the issues which were raised where it was said some people will be arrested shortly and soon. And
That you can raise with the DPP.
That's correct,
but
Your Worship.
I don't need to hear it. I will still reiterate that I am not empowered to hear that. As I'm saying that I'm seized with this matter in order to deal with the trial.
As the court pleases, Your Worship.
But not the issue that is outside what this court is supposed to listen to. That is why I even said I think this is the issue which should go to Madlanga Commission. Okay, thank you, Advocate.
That's the court please.
Thank you.
So before I can respond,
Yes, Advocate Tabu.
can I have a word with Mr. Leadership regarding the date?
As the court please. Let's go to 14, 15. Okay, it's fine. Let's go to 10. It's fine. 10,
As the court places, Your Worship, firstly, Your Worship, the state notes the defense constitutional rights to submit representation to the Office of the Director of Public Prosecution. And for the review of the decision to consolidate the charges under the current charge sheet. So we do not oppose the defense constitutional rights to submit the representation. And secondly, Your Worship, because of these new charges, the state concedes that the accused and the defense require a reasonable time to study the new allegations. And lastly, Your Worship, I've consulted with my colleagues and we mutually agreed to postpone this matter until the 10th day of September, and that will be for the defense to submit written representation to the Office of the Director of Public Prosecution.
September 2026 mwalela mulauli muhulu wa vachuchisi ka chishinyo cha vona
As the court pleases, Your Worship.
Advocate Chauke, when we started with this matter, or on the first day when the accused appeared in this court, you made an application for the consolidation of these charges in terms of, I can't remember the section, but the Magistrates Court Act. Yes. Is that not true?
No, what happened is that there was a certificate for centralization of the charges.
Yes.
And that
You
was
used that
done.
certificate.
And that was done whilst the matter was still in the district court. So we have one regional court, so we don't need that certificate. So the application in this court should be in terms of Section 81 of the Criminal Procedure Act.
Yes, but when the matter was brought here, there was already a decision for the centralization
That's
of these
correct.
cases.
That's correct.
Was that brought to the attention of the defense?
That's correct, Your Worship. It was done prior to the bail hearing of the accused.
And when the accused appeared on the first appearance, if I'm not mistaken, that was when there was addition of other charges. Am I correct?
Yeah, correct. There were matters. In fact, there was one matter which was transferred from Lehlohonolo Regional
Yes.
Court. Correct.
Yes. And it was transferred to this one to be added to these other charges.
In terms of Section 81.
In terms of Section 81.
That's correct, Your Worship.
But that was brought to the attention of the defense.
That's correct, Your Worship.
And the defense acknowledged
That's
that.
correct, Your Worship.
kana kwe mlatfatwa atwelela la mathomo pela khoro ye ibeng ya tutluwa na regional court ke mo ile gore ba ile wa kopela gore mlatfu ithapanye ka moka ke second mo motšhisar awa sephetho sa gore mlatfu ka moka e gore mlatfatwa o latfatwa ka yona wa o ile latfatwa ka yona e tlhakanywe e be filong le letseng ke se se tšero ka nako e molato o sa tswelela kwa kgorong ya seletu e be district court mo e leng gore molaodi mogolo o tšere sephetho seo ga ba ntšha le certificate sa gore o tšere sephetho seo pele le ge molatfatšwa a ka thoma ka kgopelo ya gage ya go lokolwa ka pele se se diraetseng ka mo kgorong e ke kgopelo ye e tšitšo o ya le ka karolo ya bo 81 go tšwa molaong wa o laola tshepedišo ya tsheko ya melato ya bosenyi mo e leng gore ba kgopetse gore melato ela e be e le kgolong tsheko ya lengwa kgomo e tseše keno e tle e tlaleletswe go melato e leng gore e be šetse o tšere sephetho sa gore e tle e sepe ka mo kgorong ya tukologo ya Polokwane ke sona fela se ba se dirileng go kgopela melato ya lengwa kgomo gore e tle mo kgoro ya re tše ka moka motšwisadi bolelao o ramolao ba tsebišitšwe a re ba tsebišwa ye go dirwa bjang.
Advocate Mathabata,
Your Worship.
can you remind me again when you are saying that in respect of count 1 to which count whereby you are saying that the defense is ready to proceed with the trial? Count 1 and
It's count 1 to 4.
Count 1 to 4.
Correct. I think my colleague is also aware of which counts are those.
Count 1, which is attempted murder. Count 2, attempted murder. Count 3, which is possession of firearm. And count 4. So those, when I look at the charge sheet, these are the charges which allegedly have occurred here in Polokwane. These are the counts that you are saying that you are ready to proceed with the trial conflict.
Your Worship, There are counts in Lehlohonolo which were properly transferred to this court.
Yes.
We don't have an issue with those.
Oh, okay.
We have counts 1 to 4 which occurred in this jurisdiction.
Yes.
We don't have an issue with those ones. We can do a pre-trial. We can even have them tried before this court. This court is empowered.
That is why I'm saying that you mean that these are the counts which the state alleges occurred here in Polokwane.
Yeah.
But what about those? You said something about the Lehlohonolo one.
Worship 1 to 4
Yes.
occurred in this jurisdiction.
Yes.
Now, there are counts which come from Lehlohonolo. Let's call them, they were active cases which were on the roll and pending in Lehlohonolo.
Yes.
They were transferred to this court.
Yes.
We don't have an issue with those ones. Now we have an issue with some matters which were taken from the storeroom, which were gathering cobwebs. Those matters were finalized either by mediation or they were withdrawn because the complainants and the accused had resolved their issues. Those matters are the ones where allegedly those matters are the ones where the court does not want us to address it on.
Okay.
Yes.
Now I hear you.
Yes.
I want to understand the issue of centralization because if I remember very well.
Yes.
In your address, you're saying that another issue that you intend raising with the DPP is the centralization of these cases.
Yes.
Of which the centralization, my understanding,
yes,
is that there are matters which allegedly occurred in Polokwane.
Yes.
Right.
Yes.
Then there are matters that allegedly occurred in Lehlohonolo.
Yes.
And by combining those to be heard in Polokwane,
yes,
my understanding is centralization.
Well,
is that not so?
The centralization, in as far as it relates to those cases, is not brought under issue.
Oh, that is what I understood you, sir, when you were addressing me, because
yes,
I had an understanding that you were relating to the centralization or combination of these cases of Lehlohonolo and Polokwane. That is one of the aspects that you intend to take it up with the DPP.
There's no issue.
There's no issue
with the ones in Lehlohonolo, and when they are connected to the Polokwane case and they are brought to this court for trial. No issue.
Centralization, you don't have an issue.
Yes, yes.
You only have an issue with the matters which were reinstated by the state, which were allegedly withdrawn or mediated.
Yes.
Now
let me add on top of that. And those matters also arose outside of this court's jurisdiction. They were also added and centralized. So the centralization is only going to be questioned in relation to those counts which were withdrawn. I don't know if the court hears me now.
Now. That is clear.
Thank you.
Because I thought you were talking about everything that has been centralized.
No.
Now you are saying now that you are only concerned about the matters which were previously withdrawn or mediated, and now they are reinstated and centralized.
Correct.
To this one.
Yes.
Now can you guide me? Which are those matters according to the charge sheet?
Thank you, Oship. I know one of them, Oship, would be a case of Mankweng.
Just refer me to the
Let me find quickly. Just a second. And then the other
more Polokwane I'm going to be enough for one to work for me. Abane Butatra Camilla Blue Latfadra Akasi Sayo Naga Lede Patustela, Ilitana Hotel work for mobile Itlemo Polokwane. Abane Butatra Gataka Nemela 2 Yela in 19th of October 2025. Lela Mulatfadra, Ubai Tenela, the work for me Isata, ifedishwa goba e fela bothata bogolo ke mabapi le melato ela ye e be e fedile ka mabaka a gore balle ba kgopetse gore e phumole goba e ogele morago le melato e leng gore e oke morago e fedile go ya ka tsebo ya molato ba na le bothata le ene go ya gore ke ka baka la ene bo tsere sephetho sa re ditsusulošo le bona e fe e tlhakanye le melato ya Polokwane mola e le melato ya go tswelela bo Mankweng.
There's count 15. And I suspect we also have count 7. Just a second. May I approach my client quickly?
Yes.
As the court pleases, can I? Your Worship, I'm told those counts would be count 6, 7, 8, 9, 10 and 11, 12 and 13, as well as count 14. Also count 15, 16 and 17. Those are the counts which were reinstated.
Like 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. We are at the way I'm at Fatwa, we be fedile, Yada to Shulush, Yakopana, the military Polokwane.
As the court pleases.
And the other counts 17, 18, 19, 20, except for the ones that were added today, 21 and 22.
Correct.
So there's no issue.
No, we don't have an issue with those.
Leona, Avana, Avana, Nomore over Tatra, Veluri, Balfabana, which is Wanaka, Sekishamala, Fatogayo.
Advocate Matabata, when were these matters reinstated?
Your Worship, these matters were, I'm told, they were reinstated right. Some of them when the accused was charged and when he was doing his bail applications. But the court will notice I'm coming for the first time in this matter. and the disclosure of the docket contents, I was only finished with this. I was only brought into this case, what was it, 2 weeks ago? Around about 2 weeks ago. That's when I was told I'll be dealing with the trial.
Yes.
Yes. So these issues arose in December, January. Yes.
And according to the charge sheet,
Yes.
the accused was arrested, if I'm not mistaken, was it on the 12th of November?
That's correct.
12th November last year.
Yes.
And already these charges were added or reinstated. Let's say December.
Granted.
They were added.
Let's say by January, end of January, they were added. Let's even.
Where are we now?
You are now in July, Yoshi. Yes.
Why did the defense keep quiet all along? Was this raised in the district court? Why is it raised here?
Which defense, Yoshi? Which defense?
The defense that is representing the accused.
Yeah, that is why they are not here. And I'm here. It's because
it's
because they did not raise these matters then.
Yeah, now you are raising it now here.
Because I'm here now.
When it is supposed to be now a matter to be set down for trial. Now you are raising this issue.
That's correct, because that's because I have just been served with the docket contents, and now I'm ready to proceed with the trial. And I now see we have a problem here. Things which were gathering cobwebs are brought.
We have a problem.
Now we will have them reviewed.
But
that's
the
all.
accused was every time represented. And your briefing attorney, Mr. Kumar,
Yes.
when the accused appeared here
Yes.
on the first appearance in the regional court,
Yes.
he was represented by Mr. Kumar.
Granted. No, wait. Granted.
So that is why I'm asking,
Yes.
why was it not raised? I don't know who represented the accused previously, but this was never brought on the first appearance. Mr. Kumar, if I remember very well, was only concerned by the addition of the charges from Libuachom, saying that as far as we know, the accused was facing 11 counts, and then now some counts added to be 20 counts.
Your Worship, I'm not sure if
What I'm saying is,
Yes.
advocate must understand me that it's not about the issue you are getting on record now.
Yes.
This accused has at all relevant times
Yes.
represented.
I accept that.
Yes.
Yes, but
So that is why I'm saying that now when did the defense start to know that now some of the charges are reinstated and now they have to approach the DPP and query the DPP about those charges, of which I'm not stopping you from doing that.
Okay.
It's just my concern, and you have to ask as the court, because remember now, we are at the stage of where this court was here
yes.
and ready to proceed with the pre-trial conference so that we can set the trial date and say that we proceed with the matter
Yes.
without unreasonable delay.
Yes.
Now these issues pop out. And when they pop out, they pop out. My concern is that I would understand if the accused was never represented. Now they pop up bit by bit.
Yes.
You see. That's my concern.
But Your Worship, that concern is without rather it's misplaced in as far as it seeks to find that all legally qualified persons have the same level of experience. It will be misplaced if that's the court's view.
No. I don't judge people by their experience.
Yes.
To me, everyone
Yes.
is equal before me.
Yes.
And every legal representative
is
a qualified
qualified,
representative. I don't see people to say this one is less experienced, that one is more experienced. No.
Yes.
Once you represent the accused and you are the representative of the accused,
Yes.
you are fit and proper.
Yeah, that may be. That might be.
Yes,
Yes.
that is before the eyes of the court. Before me, I see legal representatives as fit and proper people. And I don't see people to say this one is less experienced, that one. Once you appear before me, I have to regard you as a fit and proper person and respect you for who you are. That's my level.
Yeah. Can I assist the court? Perhaps we will find will reach a stage where the court gives us a ruling. The question that the court directs at me is, the accused was always represented by various lawyers, and we know there was Mr. Ramusi. At some point, my learned colleague then, my instructing attorney then took over. Now the court wants to know, why did any of them not raise these matters previously? Can I just finish? Now, if that is the question, the answer to that one is the following. I consulted with the accused after I was given the instructions. And Mr. Kumalo said to me, Mr. Matabata, now you drive this process. Now, after I took over, I have to devise the so-called a defense strategy, which I discussed with the accused. And the accused instructed me to first have these matters discussed and removed so that we can deal with the core issues. Now, as far as I'm concerned, the accused legal representative for trial is Advocate Matabata. And Advocate Matabata is trying to deal with the charges, to delimit the issues which are core and to remove the non-core issues before the court, so that the court is only concerned with the counts which we find that we are to defend ourselves from. Because the rest of the accounts, the matters were resolved as far as we are concerned.
Thank you.
Your Worship, may I just, as the accused attorney, answer a very important question that was raised by the court? And I know my learned friend, Advocate Matabata, is in no position to deal with that because he wasn't involved at the time. May I say, Your Worship, that the issue that we intend to raise with the state through representations and also take on review at the High Court is not new. It is correct. It arose at the time of his arrest. And at the time of his arrest, he was represented by Mr. Ramos, who did the bail application at the district court without challenging it. It's a fact. I came in at the time when he was doing a bail application on new facts. The investigating officer is here. We raised it, but we raised it differently. In the bail application, we raised it as a point in limine to say these charges should not have come at all. But let me just finish, Your Worship. I'm just finishing, Your Worship. I don't want to take too much time. I think we have already taken too much time. I was raising it for the purposes of a bail application. Now we are raising it for the purposes of a trial, and it's extremely important, and let me explain why, and I'm done. We do not want this court to do a trial in respect of a matter that has been finished in terms of the law. ADR, Alternative Dispute Resolution, is recognized in terms of once a case is closed in terms of that process, a trial should not follow. And that's what we are avoiding. We are actually helping this court, Your Worship, and ourselves as well. Thanks, Your Worship.
Do you want to respond, Advocate?
No, I think it's outside my mandate. I will not respond.
O apiladra kupelo ya olukulwa ka bail we bashiti batsiba oluna le merapi mengwe e le gore be ifedile ya tsushulushwa gore ka nna go ka moka mola tshwatso ba ntja ene ramolao ka ba kana ngo ramolao ba se ba tsere ka we ramolao Advocate Matabata di kilo ba tsa gore ka ba ga le go ramolao wa go gore le la ka wana ba kwa morao ba se bona na reba mmoja urubuto shara molatu ke mabone mo rome bothata o ne lotse le gore o ya le ka molao a dira botse o tshwantse a lwantshane le tsona pele molatu o ka ya tshepo ramolao Khumalo le ena a bontsha gore awa goro e tshwantse o tseba gore ba ile ba e lwantsha taba ya gore ba papa la utlwisi ba tshuluse melato e le gore be shetse e fedile e fela ka nako ena ba e dile ka tsela ya go lwantsha gore a lokololwe ka bail a ne bjale ka gore tseo tsa bail a se tse kgoro e e lebaneng le tsona e lebaneng le tsheko ya melato ke ka baka le bue bjale ba di tsweletša gape mara legatong le ba di tsweletša go direla gore pele tsheko ya molato e thoma e bane gore go boletswe ka taba ya melato ya go tsošološwa a bontšha gape le gore melato e leng gore e fedišitšwe ka baka la gore molatofatšwa le molli ba kgonne go ka fitlhelela kwano ya gore molato o se tsaya tsheko ke sephetho se e leng gore kgoro goba molao o amogela gore ke tsela e botse ya go fediša molato wa sa tsošološwa bjale ba leka go thuša le kgoro e le ge e le gore nepogolo go thuša molatofatšwa e fela le kgoro e tlo thušea ka kgato e ba nyaka go etšea gore kgoro e se ka tla ya nyaka wa hlola molato e leng gore o ya le ka molao o fedile fedi a o sa tshwanela go ka tsošwa wa sekwa gape.
If I can make a ruling in respect of the postponement of this matter, Advocate Chauke, according to the charge sheet, the accused is facing 4 counts of attempted murder. Is that so?
Correct.
And also facing 3 counts of robbery with aggravating circumstances.
I confirm.
Right. If you look at your charge sheet, Advocate Matabata, let's go together with the charge sheet. If you look at the charge sheet on those counts,
Okay.
the state has invoked the provisions of Section 51, subsection 2 of Act 105 of 1997.
That's correct, Your Honor.
Now, Section 51, subsection 2 has got Part 2, Part 3, and Part 4. Where do we fall under it?
So this is, it should be, could bear with me, Your Honor. It should be Part 2, Schedule, could bear with me. Just
Yes. Can I just ask this, because I just
Schedule
don't
2.
find it.
Schedule 2.
51 subsection 2, part
Part 2, Schedule 2.
2 of Schedule 2
Correct.
provides for a prescribed sentence of 15 years as first offender,
That's correct.
20 years second offender, 25 years third or subsequent offender.
That's
And
correct.
the very same provision, a certain subsection provides that depending on the gravity of the case, the court may add a sentence which is not exceeding 5 years, either to 15 years, 20 years, or 25 years. I just want to attach it to be clear. As much as this court has got the responsibility and a duty to explain to the accused, but it will be fair that the charge sheet must reflect the same, so that when the attorney consult with the accused, they consult on something which is clear. I know that I have an obligation to explain all these provisions to the accused when the time comes, please. So I would suggest, Advocate, I'd suggest that such be added as well, so that when you consult, and when you consult properly with the accused, knowing this, I know that I still have an obligation to explain those provisions to the accused.
As the court pleases.
I would like that the state must draft the proper charge sheet with the proper provisions. Thank
you. Una le mela tremine mo e mo la fatwa ka le ka o lai aba le mela tremera mo e mo tsa fatwa di tao re u shwe ko ka fase a maemo a shuruba a dithamile ka sera mo tsitsila me ro yalo ki me mela tria la fatwa ka yo poro ya re e le bella mo mo tsitsi uri bona bela ka fa la butshisi popolo ya bona le o ka dira o mo la fatwa a bona mo la tukamela tuku e taba ya gore foro e mfe dipotso ya leka karolo ya bo 51 motho wa bobedi e beng molao wa 105 wa 1997 e beng molao o e leng o tlhatlha baatlhodi ka bonnyane ba dipotso tse ba ka di fago ba latofatswa e ba bonwe ka melato ya go tshwana le bjale be nyaka gore mothutisi a botse kgoro gore go ya ka seripa sefe sa karolo eo ya molao ya feleletša e thuša mothutisi gore a lemoge gore ke seripa sa bobedi seripa sengwe ke se e leng gore se maatlafatša kgoro ye gore ge o ka direga gore e fitlhelele sephetho sa gore molafatšwa o molato ka melato ye ya go leka go bolaya goba go tshwara pogo ka fase ya maemo a šoro ba a ditlamedi kgoro e na le maatla a o ka mofa potlo ya go thoma ka bonnyane ba mengwae 15 goba mengwae 20 goba mengwae 25 o laola ke gore a na ke la mathomo goba ke la bobedi goba ke la boraro le go fetisa a bona molato ke kgoro ya tsheko ebile kgoro e na le maatla a o ka oketša bonnyane ba potlo ewe ka mengwaga ye sa fetio ye metlhano bjale e nyaka gore mothutisi a ngwale taba tše gabotse gore boramolao ge ba yo boledišana le molatofatšo ba mo tsebiše le taba e ka gore go ya le ka ditatofatšo tše di tlišwago ke ntho e leng gore pele tsheko ya molato e ka thoma kgoro e tshwantše e mo tsebiše semmušo e be e laela mothutisi gore a dire tše di tshwanetšego ge o ka melatong ya o leka go bolaya le go swara pogo ka fase ga maemo a šoro a fitlhamile ka segara
Thank you. Today is the 10th day of July, 2026. In the Additional Court for the Additional Division of Limpopo, Masika held at Polokwane. This is the matter between the state and Lehlohonolo, Chauke, Chauke, the accused. The matter was for pre-trial conference today.
Really, Lehlohonolo is the 10th of July, 2026. Korong Teko ya Tukulu ya Limpopo, ye Lumori I Sarelwa, Wala Polokwane. Mulatu Mobila Foro, Mulatu Moilumori, Valfabala, Valakacha, Murena, Lehlohonolo, Chauke, Lehlohonolo, Verupila Foro, the Matakuri, Amavidi, even now Fabala, Valfabala, the Tabula Fatwa, but to be said for Rory, but the Kamukazi, Sanity, or the Katoma, Seka. Malatuna.
Advocate Sapo, with regards to count 8, please just endorse that this count has been endorse it and then you initiate, so that if somebody else comes next time, it must be clear that it is with you. Thank you.
For recognition of the story, I want to go with Namola evidence I know Malatula 8. Your budget is petrol, Sao Kumula, or Wogana Marao, Awasato, Sekishamala, Patokao.
The state applied to add 2 charges, which is culpable homicide and its alternative, as count 21, and reckless or negligent driving as count 22.
Papa, which is well, this is your football lawyer, or the Teddy to Fatro, Catalanola Fatwa, or Milatu, even Malatu, Wow, for the Polamotu, Esica, my finish to Elita, Maushai, Malatu, or the last Fatana, Velika, Malatu 21, or 22.
The state withdraws count 8, which is possession of unlicensed firearm. Now the total count is 21.
Malfa Balau Chuchisi, Vajas Petrosa, Mula 8, Oraori, Kakare Choparo, Yamila 2, year 21.
Advocate Matabata, on behalf of the accused, did not object to the addition of the charges, citing that the state cannot be stopped from adding the charges.
Advocate Matabata, I met Mulat Fajwa, Asi, Anganishanale, Travari, Tarimila, Tuval, Fabala, Chuchi. Tuleta, Travari, Auna Sevaka Sidrao, Yakamala, Sivela, Fabala, Chuchi, Fatamula, Fatwakai.
However, Advocate Matabata submits that in view of the addition of other 2 counts, the pre-trial conference cannot proceed as they are not ready to proceed, as Advocate Matabata needs to consult with the accused in relation to the additional charges.
If I want to cover Galawi, Balfabala, which is what I will tell you, Sesira or Bagas, Ponjola Billy, will need to fight it up for Royal Woli, Kamukari, Atoliciamo, the Katuma, Sepamula, Tugawi, Ugo Fokawoli. I have lived in a lot for Billy, Ka Milatuye Mission.
Advocate Matabata further raised the concern about the addition of other counts or addition of other counts which were withdrawn or were resolved through the alternative dispute resolution with the complainant who may the having no interest in the matter.
Advocate Matabata wila kulika bila yetu mabapili milatuye lumori logetri umilatuye ya Polokwane mola ili milatuye lumori ibe felicitwe ka wabalo marawo ba ukumulwa yemingwe ki felicitwe ka mifa ya kwano marenga molatfatwa le molle gore molle asana khate ya witwetsa pele.
According to the submission by Advocate Matabata, the charges which he has concern about relates to counts 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17.
We are Advocate Matabata Melapil Mori ba Kotofale Lori Tushulushe ki Melatu ya Utoma Gumalatu 6 Gumalatu 6, 7 Wabu 8 Lehlohonolo Ukumutu Wabu 9, 10, 11, 12, 13, 14, 15, and 16.
In addition to his submission, Advocate Matabata submits that they, as the defense, intends to make representations to the DPP and to find out as to how did they reinstate those matters.
Ba tibiste khoro Advocate Matabata gore bale wana bana la maikemisetso a o malla molaodi mogolo wa batšhutšhisi gore a fe ditlhaloso tsa gore go tlile bjang gore melato ye e tsošološwe ka fase ya mabaka a mafe ke mang a kgopetše o le gore melato ye e tsošološwe.
According to the defense, they are of the view that there was an abuse of power by the DPP or the state in relation to the legal process which was unlawfully applied.
Well, we are ka boramolao ba nyaka go lemoša gore bo bile le go šomišwa ga maatla bošaedi go tšwa letlhakoreng la batšhutšhisi.
It was further submitted that the defense, in their representations to the DPP, they wanted the DPP to implore the decision to centralize those added cases which were initially withdrawn or resolved through ADR.
Banaka gore molaodi mogolo wa batšhutšhisi a lebelediše ka boswa sephetho sela sa gore go kopanywe melato gore e be go tee yela e leng gore e be e fedišitšwe ya tla ya tsošološo.
The defense seek to hear as to who instructed that those matters be reinstated and under which circumstances were the matters reinstated and centralized, and the reasons to be advanced for such centralization of those matters.
Ba re ba nyaka gore molaodi mogolo wa batšhutšhisi a tšweletše gore ke ka baka la eng goba ke mabaka a mafe a filweo gore go tšeiwe sephetho sa gore melato ye ka moka e kopanywe e be felong le tee ke mang a tšere sephetho seuwe a kgopetše ke mang.
And whether there was any J17 issued to the accused to indicate when the accused was supposed to appear in court.
Le gore a na mashala ba tsošološa melato ewe ba ile ba latela tshepedišo na ya maleba e beng ya gore ba ngwane le molatofatšwa sengwalo sa go mo tsebiša gore molato wa gore wa tsošološwa ebile o tlo tsena kgorong ya tsheko neng.
The defense wants to know and to check with the DPP as to which policy of the DPP directed the NPA to properly or to add those charges and whether such policy was properly applied in relation to those cases which were reinstated.
Kamol Fabiola Chuchisi, Utias, Petrosesa, Ori, Sushu Milatu, Yemla Fadra, Atbawi Fedi.
The defense submits that they have no problem to proceed with the pre-trial conference in relation to count 1 to count 4. The intention of the defense is to the effect that if they do not receive positive results from the DPP on their representations, their intention is to take the matter for review by the High Court in relation to all the counts which were, according to the defense, were withdrawn or were finalized through ADR.
My team is not here already. Then already about to tell the plan Yemlauru, Molo Chuchi, Batola Biga, within Chapupelo, Koronkulu, Ori, Batudi, Baolo Level, Ori, Anna, Petroses Cheruki, Fabala Chuchisi. He said to Ghana.
The defense applies for a period of 2 months in order to exercise that right on behalf of their accused to approach the DPP and present the representations, failing which to approach the High Court on review basis.
Baba kupela tigana ya kwedite pedi be matati ya 60 ore badre tulotieka mukati ngore ba wonchiche ore bana le mai to auditira chawa mana le mela tuyela ya
and further to consult with the accused to prepare the representation.
Le na prewe ira kupela itaba ya kareja ore ba kono la fasino la fatwa ba bole disane mawapili cheka mukati ngore.
On behalf of the state, Advocate Chauke responded as follows. The state noted that the defense has a constitutional right to submit representation on the reinstatement of the matters that the defense has concern about.
Balfabala Chuchisi, Viola for Tabagori, Mulatfadra, Nalitukelo, Yalagamala, Chewana, for a accurately with Filaejo, Lewu, Shishina, Umlaudim, Mulova Chuchisuri, King is a our now son to the Rega, Kamala Fadro.
Advocate Chauke concedes that indeed the defense will need time or require time to consult with the accused in relation to the 2 counts that were added, which are new counts. I would say count 21 and 22, although now it will be count 20 and 21 because count 8 has been withdrawn.
Oramula olimula fatwa bato fokanako ya urelishana wa urelishana kamila tu yeye mibedi ngori ile atale le twa lokolo ye ngori pele upumura mula tu la 8 ibe itoba mula tu 21 wa 22 pele kar mula tu 8 upumuchu itoba mula tu 20 wa 21.
Advocate Chauke did not want to dwell much in relation to the intention by the defense on this representation pertaining to the counts that the defense is concerned about, and citing that he has no power to can dwell about that.
Advocate Chauke asenaka ulela kudu ka maikimishe jo Mulatfadra Malela Mulaudi Mulu wa Chuchisi Leu Ujala Pelecautin Chapupelo Koron Hulu Mawapili Meladrilla ya go gogelwa morago goba ya go fedišwa ya tsošološwa a bontšha taba gore yena maemo a gage ga mo dumelele gore a fatlhele ka teng.
Ruling, the application by the state to add 2 charges is hereby granted.
Kgoro e afola ka moka tse di boletšuwa dikgopelo tse di tlilego ka tsela ye sa mathomo e dumela gore ba lefapha la botšhotšhisi ba tlaleletse melato ka ela e mebedi.
Count 8 is withdrawn against the accused at the instance of the state, which means now the accused will be facing 21 counts, not 22 counts.
Molato ola wa bo 8 kgoro e gatisa mola gore o phumotšwise mmušo o ya le ka kgopelo ye tlisitswego ke ba lefapha la botšhotšhisi se se ra gore ka kakaretšo palo ya melato ke 21 a e sa le 22.
Now, in relation to the postponement pertaining to the submission by the defense that the postponement be for submitting their representations and failing which to take the matter on review to the High Court. This court will grant the postponement, but not on the basis of the representation being taken by the defense to the DPP and sorting out the issue of the review. I will deal with that briefly as to why. I am granting the postponement of this matter for the period that the parties have requested on the basis of the 2 additional charges that the state has added, because it will be unfair for the accused to proceed with the pre-trial conference when the accused has not consulted with his attorney on these new charges in order to respond to the attorneys as to what is it that the accused needs to reply on if the trial is proceeding. So that one, it will be unfair if I refuse the postponement. I'm granting the postponement on the basis of the 2 charges. The accused needs to have a fair trial to know what the charges is facing and to be able to answer to those charges, meaning that the accused has to be able to challenge the evidence which will be presented on those charges during the trial.
Mabaka ore dumele a se ka baka la gore boramolao ba yo ngwalela molao wa batšhotšhisi le gore ba ka no tswela pele ka kgopelo ya o ipilaetša kgorongkgolo e re e fa e dumela gore molao o šotšhetswe pele go ya le ka mokgwa motšhotšhisi le boramolao ba kwane ka ona go fa molatofatšwa le boramolao ba sebaka sa gore ba dule fase ba boledisane ka ditatofatšo tše pedi ba melato e mebedi e leng gore e tlaleleditšwe ka gore molatofatšwa o santse a fiwe tsheko ye tuka a dumelelwe go ketiriša a ketutišetša tsheko ya molato wa gage go lekane e sona se se dira gore kgoro e dumele gore molato ka no šotšetšwa peeletše ka no ya matšatši a 62 ba kgweditše pele.
I further wish to state that this court does not stop the defense from exploring the other avenues, like submitting the representation and taking the matter on review. No, this court does not stop the defense from doing so. Within this period, such can be done.
I ganetse molatofatšwa ka mo go ba ka thušo go tswa wa boramolao ba gage gore a ngwalele molaodimogolo wa batšhotšhisi a leka go bontšhana le yena se se swanetše go direga mabapi le melato ya latofatšwa ka yona ebile a e thibele molatofatšwa gore ge a bona go ituka a tsentše kgopelo ya gage o baatlhodi ba kgorongkgolo gore ba lebelele gore ana dipheto tse di tserwe ke ba lefapha la botšhotšhisi di tsetšwe ka na ge o itla melatong ya latofaditswago ka yona dilo tse nngwe o kgweditse tse pedi tse molatofatswa ka thuso go tswa go ramolao a ka no di dira.
However, this court also has a duty to control the proceedings in order to curb the unreasonable delay in the proceedings of this matter.
Efela kgoro e e na le maikarabelo a o laola tshepedišo ka mo kgorong e go netefatša gore molato a o tšee nako fitlha mafelelong ka mabaka a o se kwagale.
This court is bound by the norms and the standards of the Chief Justice that matters are to be expedited and to curb unreasonable delays in the matters.
Kgoro e tlama ke melao ye e beilwego ke moatlhodi mogolo wa naga ya Aforika Borwa ge o itla go laoleng le nako ye e leng gore e tshwanetse go tšeiwa ge o atlholwa goba o sekwa melato ya go sele.
The accused has a right to a fair trial by all means.
Molatofatso o na le tokelo ya gore ka ditsela tsotlhe a fiwe tsheko ye toka.
The complainants or the witnesses, in the interest of justice, also have a right to know what is happening in their cases.
Molle wa balle ga mmogo le ditlhatsi tše di ameago ba na le tokelo le bona go tseba gore go diragala eng ka melato ya.
And this court has to treat everyone equally. That means everyone is equal before the law. And this court has to apply the law within the ambit of the Constitution as envisaged in Section 165 of the Constitution, Act 108 of 1996.
Kgoro e swantse e sware batho ka moka ba e leng gore ba tswelela pela yona go lekana e netefatse gore ka moka ditokelo tsa bona a di gatakwe le go netefatsa gore tshepo ya melato ke e tuka e phethagatša se e leng gore se gatišitšwe karolong ya 165 go molaotheo wa naga.
There will be no prejudice if the Trial Conference proceed in this matter whilst the accused is taking the matter either for representations, if the representations are not successful, taking the matter on review. Then the review can proceed to the side, but the Trial Conference can proceed to the side.
Kgoro e re a ona ntho mpe e leng gore e tla tlhaela molatofatswa ge e le gore yona ka mo letlhakoreng la yona e tswela pele go kwa go tswa go matlhakore ka moka gore go ya le ka seemo ka mokgwa o se beng ka ona a na ba loketse go tswela pele ka tsheko ya molato ba beakantšhitše dilo ka moka na ba kwalela letšatši la tsheko le ge e le gore ka letlhakong le lengwe molatofatswa o tla ba a ntše a lweša se a se lwešago le molaodimogolo wa batšhotšhisi goba kwa kgorong kgolo.
Even during the trial, if the trial is proceeding, there's nothing that prohibits the defense to can proceed to the High Court on review on any aspect when the trial is proceeding. There's nothing that prevents the defense from doing so, but that will not also stop the trial from proceeding.
Le ge tsheko ya molato e ka thoma a ona ntho e thibelago molatofatswa ba lefapha la botšhotšhisi gore ba iše dikgopelo ba boipelaetšo ga bona kgorongkgolo mabapi le ntho e nngwe le nngwe ba bonang kare a e tuka ba e sepele gabotse e fela sewe se ka se thibele gore re tswele pele ka tsheko ya molato.
I'm saying this regarding the trial making a reference to the case of Vincent Madiga versus the state, the Limpopo decision, where the court, that is Limpopo, a high court, was concerned about matters which are taken on review when the trial is proceeding, and the judge held there that it cannot tolerate matters which are taken in piecemeals rather than waiting for the matter to be finalized so that the matter can be dealt with when it is taken on appeal.
Vincent Madiga o va I dirile bopile tlo kgatlhanong le mmuso wa ba lefapha la botšhotšhisi ke molato e leng gore o atlhotswe ke kgorokgolo ya mo Limpopo mo e leng gore moatlhodi o boletse taba gore a kgone go kgotlelela he batho ba tliša boipelaetso ka diriparipa ba sa no emela tsheko ya molato e fela ba ipelaetse ka ntho engwe le engwe e leng gore a ya ba kgotsofatša mohlang molato o sele.
In the circumstances, the following order is made.
Ka fase ya seemo se se tsweleditswe mo lekgono kgoro e fa ditaelo tse latelang.
On the 10th of September 2026, the pre-trial conference shall proceed in this matter.
Ka letsatsi kgwedi ya 10 September 2026, kgoro re tlo tswela pele go kwa go tswa go matlhakore ka bobedi gore ka moka ba di beakantšhitše gore re kgone go kwanela letsatsi la tsheko.
And it is expected of the parties to be ready to proceed with the pre-trial conference, because I've made an order to that effect. And I reasonably believe that this is sufficient time for the parties to exhaust whatever issues they may have, so that on that day, with or without the outcome of the review or the outcome of the representation, the pre-trial conference shall proceed. I thank you.
Kgoro e re ka e file taelo e tsebiša matlhakore ka moka gore ba tle ba lokile go tlo kwanela letsatsi la tsheko ka gore tekano ya go tloga gane bjalo ba go fitlhela 10 September e bona e le nako e lekaneo gore ge e le go na le boipelaetso e le go na le tse dingwe tse leng gore ba nyaka go di dira goba di tlhoka go diriwa di ka diriwa e ka ba boipelaetso kgorongkgolo ba e ka ba go ngwalela molaodimogolo wa batšhotšhisi ke nako e lekaneng kgoro e re ya leboa re tla kopana ka di 10 tsa September ngwaga 2026.
Please stand up, Mr. Chauke.
Kgopela wa emelela.
This matter now is postponed to the 10th day of September 2026 for pre-trial conference at 8:30. You are in custody, so you have no bail. Advocate Matabata, instructed by Mr. Kumalo, is your legal representative. You will be brought back on that day.
The 10th of September o tla bušwa.
May I approach you?
Yes. I just want to endorse in the reason the officers want me to leave so that they can come.
Your Worship, the accused requests that the court makes an ancillary order.
Yes.
He says his medication, rather he has run out of medication in the prison.
Yes.
And he's asking that he be kept here at Polokwane police station.
Yes.
So that he can be able to access medication.
Where does he get the medication from?
Well, if he's at the police station, his doctors can be able to access him easily to give him medication.
The doctors cannot go to prison.
It's rather difficult there.
Thank you.
That's the court process. So all he's asking is when the J7 is prepared, rather they put him at the police station.
Fortunately, Advocate Matabata, we had a meeting with the correctional officers together with the kennel here at the police station. We canvassed the issue of the accused who are kept in prison who are sick.
Yes.
And I was informed by the prison authorities that every day they go around in the cells and ask the people who have complaints, and those who are sick, they are being attended to. There is a nurse every day. Then on Tuesdays and Thursdays, there are doctors who see those who are ill. They even told me that if it happens that the sickness of the inmate is beyond their control, they take them to the hospital themselves and they guide them. As a result of that, I've got this register is a copy as well, from the prison authorities, where they every day take rounds of the complaints of the people. If you can see here, from these dates, there were no complaints. Then on the date of the 6th of June 2026, your client, Mr. Lehlohonolo Chauke, wrote a request, and they endorsed it here. But that request was in relation to the date, because he seemed to have forgotten as to when was he supposed to appear in this court. And it was written here that the date, according to the J7, he's supposed to appear today, the 10th. So what must happen is Mr. Chauke must tell the prison authorities that he needs the medication. If ever there needs to be a change of the medication, he must request that he be taken to his doctor. They will do so. Failing which, if they don't, then the representative of the accused must take it up with the prison authorities. That is what I was informed. It's beyond my powers. Advocate, he must report to the prison. If they don't help, then he must report to you. Then you take it up and you phone the area commissioner of the prisons that there is a complaint of this, because there appeared to be some problems with regards to the inmates who are kept in prison and being kept here for the purpose of to be taken for medical attention. So that is the situation. I cannot write anything but to ask Mr. Chauke to consult with the prison authorities. If they ignore him, then he must report to you or to Mr. Kumar.
That's the court.
Thank you.
It's okay. We'll find other ways as the court pleases.
The court adjourns. We shall come back at 10 to quarter to 12, please, so that I can deal with other matters. Thank you. The charging and thank you.